If you're in a high asset or high conflict divorce, pay attention. Court orders are orders. And if you control businesses, investment accounts, or complex structures, this applies to you. Welcome to Details in Divorce, where we break down the legal, financial, and emotional aspects of divorce to help you make informed decisions. I'm your host, Paul Riley, and each episode we dive into key issues that impact individuals navigating separation and divorce. So, whether you're concerned about asset division, protecting your business, or dealing with high conflict disputes, we're here to provide clear, practical insights. Now, divorce is complex, but understanding your rights and options can make all the difference in the world. And while this isn't legal advice, it is designed to empower you with the knowledge you need to move forward and to do so with confidence. Today, what does it take to go to jail during a divorce? Well, not missing a payment, not arguing in court, not even being difficult. In Carter v. Carter, a 2026 case, the Ontario Court of Appeal upheld a 90-day jail sentence against a father in a high-conflict family case. Now, let me explain something. Judges, they don't throw people in jail frivolously. In Canada, generally speaking, not even in criminal court, family law court even less so. You've got to really cross the line for a family court judge to tell you, go do jail time here. The judge said a longer sentence could clearly have been justified. So what exactly did the father in this case do? He ignored a court order. Not accidentally, not once, repeatedly, over years. If you're in a high asset or high conflict divorce, pay attention. This case involved a preservation order, a Mariva style freeze. And that essentially means the court restricted movement of assets because it believed there was a real risk that the money would disappear before the trial. The order was clear. The father knew about it, and despite that, he continued operating accounts, moved funds through multiple accounts, opened new accounts, shifted money in breach of the order. This wasn't confusion. It wasn't sloppy bookkeeping either. The trial judge found it was intentional. The result? Civil contempt and 90 days in custody. The father appealed, and he lost the appeal. Civil contempt has three elements. One, the order must be clear. Two, you must know about it. And three, you must intentionally breach it. In this case, all three were satisfied. The Court of Appeal rejected arguments about procedure, self-incrimination, and fairness. Dad, in this case, had notice. He had legal advice. He chose how to participate. There was no injustice, there was noncompliance, and appellate courts do not rescue deliberate noncompliance. As I stated earlier, jail in family court is rare, but it happens when the misconduct is serious enough. The trial judge focused on denunciation and deterrence. The Court of Appeal agreed. They looked at the years of misconduct, the magnitude of funds involved, the deliberate movement of money, the absence of meaningful mitigation. They looked at the rejection of health arguments as well. And here is the key. The court stated that an even longer sentence would have been warranted. Now, that's not subtle. That's a warning. When someone treats a preservation order like an inconvenience, courts tend to escalate. This wasn't a legal mistake. It was a strategic one. Moving money after an asset freeze, opening new accounts, then arguing that you can't pay because you depleted assets. The court explicitly noted that any financial inability, in this case, was self-created. Now, that's going to destroy credibility. And once credibility is damaged in family court, everything becomes harder. Support arguments, cost arguments, future motions, settlement leverage. You cannot outmaneuver a clear court order. You can challenge it, you can appeal it, but you cannot ignore it. And I've said this on several occasions, court orders are not like mere suggestions. not unlike a maitre d' suggesting one should have the Cajun ribeye instead of the sea bass. Court orders are orders, and if you control businesses, investment accounts, or complex structures, this applies to you. Preservation orders are not suggestions, they are red lines. If you cross them deliberately, the issues shift from financial dispute to integrity problems. And once the court sees you as someone who manipulates the process, you lose strategic advantage, and you do so real fast. Appeals will not save you from intentional conduct. Technical arguments will not resuscitate you from credibility damage. And jail, while rare, is absolutely on the table when defiance is prolonged. The bigger lesson here, high conflict divorces are often lost because of ego, feeling controlled, feeling cornered, feeling financially restricted. That's when people make reckless decisions. Strategic compliance is not weakness, it's discipline. If you disagree with an order, you challenge it properly. You do not test the boundaries, because when contempt enters the file, you are no longer arguing about money, you're defending your integrity, and that is a far more dangerous position. This case is not about punishment, it's about consequences. If you're navigating a serious family law matter, understand this. The smartest move is rarely the most aggressive move. It's the most controlled one. Because in family court, control beats defiance every single time. That's it for this episode in Details in Divorce. We hope you found today's discussion insightful and valuable as you navigate your own divorce journey. Remember, every situation is unique, and getting the right information is key to making the best decisions for your future. If you have any questions or need guidance, the Riley Firm is here to help. Be sure to subscribe so you don't miss our upcoming episodes, where we continue to explore the critical issues that matter most during divorce. I'll see you next time.